Aloha mai kako. My name is Diman Kalaya Manaole. And in this series, this video, I want to cover the question of the political question doctrine. And I wanted to make it clear to everybody out there uh, that the political question doctrine, I believe, is the most fundamental and most powerful doctrine or law. Sometimes doctrines can be have the force and effect of law, right? Courts use it all the time. Doctrines, right? Uh, has the most impactful and meaningful um, avenue for Native Hawaiians, who is 50% or more blood quantum, to be able to deal um, with our lands, our trust lands. So if you're a person of Native Hawaiian descent, and I would have to extend that all the way to 132nd, and I'll explain why as we go along. But I wanted to be able to brief with you um, my understanding of this very powerful doctrine called the political question doctrine. And to do so, I want to pull up a case of one of our famous palalas that's in Lahui, Uncle Pat, Kahawai Ola'a, right? And Uncle Pat was part of a lawsuit versus Norton, right? And I want to take you past all the initial stages all the way to the Ninth Circuit Court of Appeals. And it is here that we will learn the power of the political question doctrine. And what the bottom line is one, just do 'em. Just act on it because the laws is already there. And in so doing, you force the other side, the opposition, to take action, knowing full well that you are protected. But you gotta act accordingly, right? So I'm gonna tell you off the top, when we're talking about political protests and we're talking about the political question doctrine, in the context which I am talking about it, I'm not talking about holding signs on the side of the road, um, chaining each other up and blocking passages and yelling and screaming at whoever, cops, politicians, whatever. I'm not talking about that kind of protest. And for me, that kind of a protest, um, you know, Mauna Kea was a great expression of the protest, and that was all fine and dandy because it served its purpose. But for me, I had some more time and energy to engage in that. That is you taking the fight to them. You taking the fight to them, and you're saying that by your waha, by your actions, you can just go ahead and get them to comply. That's not always going to work. But what I'm talking about is you getting them to react to you. See, that is the essence of the art of war by Sun Tzu. He who can win the battle without fighting, that is the general that has mastered the art of war. And I want every one of you to master the art of war. So let's go take a look. So the case that I'm referring to is Kahawai Ola'a versus Norton, 386. This is the legal citation, so you can look it up for yourself. 386 F3D 1271. Now, nothing that I have here is intended in any way to provide you with legal, um, uh, um, what do they call that? Um, Giving you legal advice or to represent you in the courts or anything. I'm simply sharing what I've learned. I have 37 years of pro se experience as a pro se litigant as well as paralegal studies. So I'm basing this information on my own understanding and my own uh, ideas about this, and none of it should be taken as fact. What I suggest to you is go read them yourself. Go read them yourself and apply them accordingly, right? However you deem fit. And remember, as a pro se litigant, you are your own lawyer. Now I know that adage, the age-old adage is he who has uh, a client for he who has uh, who represents himself has a client for a fool, right? Yeah, I've proven that statement wrong many a times. Okay, go check my jacket. You'll see. So let's get to it. So we see in section 2 of Uncle Pat's case, it says at the outset we must decide whether the issue before us is justiciable, or whether, as the district court determined, the political question doctrine precludes our consideration of the merits. Right? So the Ninth Circuit is saying we need to see is does the political question doctrine preclude our consideration of the merits of this case? And the Ninth Circuit said we conclude it does not. And there's a reason why they said it does not, which means they can answer this political question. There's a reason why they could. That's totally different from the political question that I'm talking about. They tried to bring a political question in there, but it never worked for them. And I'm gonna tell you why. The case gonna tell you why. As Chief Justice Marshall observed in Marbury versus Madison back in 1803, questions in their nature political, or which are by the Constitution and laws submitted to the executive, can never be made in this court. In Baker versus Carr, the Supreme Court examined the political question doctrine and established the contours of the inquiry. Right? So when it comes to the political question doctrine, they're gonna they're gonna they're gonna check it out. They're gonna view it in the context of the contours of the inquiry. So it depends on the inquiry, right? That is important. Okay. So there are 6 different ways in which the court will look at an issue and determine whether or not it is a political question, a purely political question that must be resolved by the state legislature or by Congress. So what they said is prominent on the surface of any case held to involve a political question. So in any case that involves a political question, is found a textually demonstrable constitutional commitment of the issues to a coordinate political department, such as Congress, the legislature, city, the city council. Those political departments is the only place that this issue, this purely political question, has to be demonstrably established, right? Or a lack of this. That's one. That's the first one. The next one is, or a lack of judicially discoverable and manageable standards for resolving it, right? That's important. Remember these words, right? Number two. Number three, or the impossibility of deciding without an initial policy determination of a kind clearly for non judicial discretion, right? So it has to be that there's an impossibility of deciding this question an initial policy without an initial policy determination of a kind clearly for non-judicial discretion. It's got to be a non-judicial discretion, right? Or the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government. Now that one is powerful because if they're not respecting, each branch of government is separate and distinct. It has its own powers, right? The supremacy clause. Each branch is co-equal to each other. No one branch is greater than the rest, except in the Trump world, you know, all the branches bow to him, right? But in Hawaii, we still get that. Or an unusual need for unquestioning adherence to a political decision already made. Now that is a very good point. Or an unusual need for unquestioning adherence to a political decision already made. If the political decision has already been made, hands off, bro. We're not gonna touch them. If the political decision has already been made, they cannot touch it. Or the potentiality of embarrassment from multifarious pronouncements by various departments on one question. So if every department get its own opinion about this one thing, it's going to be an embarrassment to the entire system because they cannot agree on everything, right? That is a political question as well. So I like number 5 the best. Couple of the other ones, we get some support from that. Number 2 being one of them. We have that ability. But number 5 in these pronouncements is where we at. Now, let's get there. The Supreme Court observed that unless one of these formulations is inextricable from the case at bar, there should be no dismissal for non-justiciability on the grounds of a political questions presence. The doctrine of which we treat is one of political questions, not of political cases. Okay? So, if it has to be, unless one of these formulations is inextricable from the case at bar, there should be no dismissal for non-justiciability. You cannot say, we don't can touch them because that's purely a political question. It has to be extricably as part of the case at bar. It's gotta be that, right? That's important, bro, to understand. If you're going to make a move on a political question, it's gotta be the political question, the thing, and not anything else but the thing. And remember that. That is extremely important. It's gotta be the thing and cannot be anything else. Remember that. If the question before us were whether a remedy would lie against Congress to compel tribal recognition, the answer would be readily apparent, of course, right? Yeah, if it's up to Congress, hey, it's up to Congress. There is a textually demonstrable constitutional commitment to Congress to regulate commerce with the Indian tribes. So that's a law. That's on the books. There's a law that says Congress have a right to regulate commerce with Indian tribes. That is a law. It's already on the books. So it's inextricably tied, right? So if it's something that's inextricably tied, the question can get involved. Thus, the Supreme Court has often declared that based on this and other provisions of the Constitution now also, so you got to remember now, there's a doctrine called in pari materia, I-N, next word is pari, P-A-R-I, and the last word is materia, M-A-T-E-R-I-A. In pari materia means you read two of the statutes together, you can form an idea of what it is, right? It clarifies it even more. That is important. Okay? Going forward. All right. Thus, the Supreme Court has often declared that based on this and other provisions of the Constitution, Congress possesses plenary power over Indian affairs, including the power to modify or eliminate tribal rights. Pursuant to this plenary power, Congress has the power, both directly and by delegation to the President, to establish the criteria for recognizing a tribe. Thus, it is quite correct to say that a suit sought to direct Congress to federally recognize an Indian tribe would be non-justiciable as a political question. So, if you was to bring one suit today saying, "Hey, Congress, you gotta recognize the tribal rights," you cannot. The question can get involved. Somebody go, "Hey, I'd like to file an injunction about that." Go in the courts. No can, because that is totally within the purview of the Congress. Now, here's where we're gonna run into. And here's where a lot of people run into problems, especially in this case. They're run into this problem. The first problem that they're run into will be cited shortly, not by me, but by the courts. Thus, okay, in this case, U.S. versus Sandoval, 1913, explaining that the questions whether, to what extent, and for what time Indian groups shall be recognized and dealt with as dependent tribes, requiring the guardianship and protection of the United States, are to be determined by Congress and not by the courts. So, again, repeatedly, it's Congress, not the courts. For the same reason as courts have recognized the action of the federal government in recognizing or failing to recognize a tribe has traditionally been held to be a political one, not subject to a judicial review. So if it's a political one, the courts can get involved. Now here we go. What is the next statement? However, that is not what plaintiffs seek in this action. In this action, Uncle Patem was not seeking that. Rather, they seek to invalidate a provision that forbids them from applying to the Department of Interior for recognition under the same regulatory criteria applied to indigenous peoples in other states. That presents a different question and a different issue for application of the political question doctrine. See, we gotta stop trying to be creative and recreate the wheel. The very first problem that was brought forth by the Kahawai proponents was that they didn't go run to the courts. Run to the court saying, "Hey, you guys gotta do this, you guys gotta do that according to the laws." But there is a specific provision that forbids them from applying to the Department of Interior for recognition under the same criteria, which is why that whole Kanai Ovalu and all that was all bogus, because they had no authority to do that. You cannot force the Department of the whole DOI thing was a farce from the beginning, because this ruling says so. It's not me, it's the ruling says so. However, that is not what plaintiffs seek in this action. Rather, they seek to invalidate a provision that forbids them from applying to the DOI for recognition under the same regulatory criteria applied to indigenous peoples in other states. That laws don't apply to us. So why we was over there chasing that tail? It was bogus from the very beginning. That presents a different question and a different issue for application of the political question doctrine. And there you have it. That right there. That thing right there. And the problem is that they won't go to the courts to try to solve that problem. If you gotta go court to try to solve that problem, you're already on a losing. If you're thinking that, if you're thinking, hey, you know, I go court, I go court, bro. I go court and we're gonna challenge them in a court using a political protest question. You're already in left field. That's it. You gone, because it's like you're acquiescing to the courts to answer that question. You know who got to go to the courts and try, or who will go to the courts and try to do that? Is your opposition. You just present it to them and let them decide if they like go to the courts. Kick back, bro. Relax. Read the laws, and then you're good. If you read the laws and you understand the laws, you don't have to ask anybody. Do you ask anybody in your home if you can go use the restroom? Do you ask anybody in your home if you can go grab something to drink from your refrigerator? Do you ask permission to sit down anywhere in your home or to watch your TV? Do you ask anybody that? No. If it's something that you already been granted, why are you asking permission? You know, the thing that gets me with this is that by the very virtue of the creation of the Hawaiian Homes Commission Act, the federal government has already acted. They've already spoken. They already recognized Native Hawaiians. They already did that. The Hawaiian Homes Commission Act does that. Section 10H-2, the Hawaii Revised Statutes already recognized Native Hawaiians. Read it, right? And both of those sections I just cited, Section 101 of the Act and Section 10H-2, both talk about purpose. What is the purpose of the Act? So let's go out of this case now. Now that we understand what that case is all about, you know now what it is. So, I asked the question, what is the purpose? What does the purpose mean in a bill enacted by Congress or by the legislature, right? What is the purpose? And it says, a bill enacted by Congress, purpose, refers to the overall objective and intent behind the legislation. In the act, the purpose is the intent. That's what the purpose is. Why did they make this law? They expressed the intent. Okay? Remember, that's important, right? So if you read the purpose of any law, you're going to find out what the intent of that bill was. You don't have to go shuffle through 1,000 million papers. You just got to read the intent, the purpose, and the purpose is the intent. This purpose guides the interpretation, and application of the law by courts and regulatory agencies. It explains the specific problem the bill is meant to address and what Congress hopes to achieve by enacting it, or the state legislature, right? So purpose, how purpose is expressed. Purpose clause. Bills often include an explicit purpose clause at the beginning of the beginning to clearly state the goals of the legislation. This is especially common in complex laws. So they stated off the bat what it is. So what is Section 101 of the Act? What is Section Hawaii Revised Statutes 10H-2? What does it say? Read it. What does it say? Please read it. And read it in pari materia. Findings section. Many significant bills also contain a findings section, which outlines the background, issues, data, and rationale that led Congress to act. This provides important context for understanding the law's purpose. So the legislature, they go, whereas we find this, that, the other, and whereas we find this, that, the other, and whereas we find this, that, the other, and that's why we created this. Yeah, that's what they're talking about. And then legislative history. Documents created during the legislative process, such as committee reports, hearing reports, and floor debates, can help clarify the legislative intent. Judges may consult this history to resolve ambiguities in the statutory text. That is, if in a sense that there is ambiguity. But if the law has no ambiguity, we run it with the purpose. Now, let me ask you. This is the $64,000 question that I have for everybody out there. What did the U.S. Congress mean when it stated that Native Hawaiians have the right to self-determination? Well, that's a trick question because Congress didn't decide that. They didn't. So where did Section 101 of the Act come from? It came from session laws in 1990 of the state of Hawaii under Act 349, Section 1. That's where it came from, in 1990. So it's fairly recent that they put a purpose clause in there. And in 1993, they created 10H-2. That's where our power comes from. So that means the state legislature was all alone in creating that. It said what it is for Native Hawaiians. What else did the state legislature state for Native Hawaiians regarding the Hawaiian Homes Commissions Act? Do you know? 2017, they created the 132nd. They created that too. Now, whether or not the thing gotta be approved by Congress and whatnot, that's for somebody else to decide. But do you realize that when the state legislature speaks and they pass these laws and the governor signs them into a law, or lets it become law without a signature, like in this one, this Sessions Laws 1990 Act 349 Section 1. It got into law without his signature, right? He never signed them. But that is the voice of the people. That is what they're the representatives of the people. So all the state of Hawaii will agree that this is the law of the land in Hawaii. The purpose of the Hawaiian Homes Commission Act. The purpose of 10H-2 is what the people said through the legislative representatives. Remember that. Okay. So let's read Section 1 of the Act. Section 101 of the Act. Purpose. A Congress of the United States and the state of Hawaii. Now, this is the state of Hawaii saying what Congress is saying. As they would declare that the policy of this act is to enable Native Hawaiians to return to their lands in order to fully support self-sufficiency for Native Hawaiians and to the self-determination of Native Hawaiians in the administration of this act and the preservation of the values, traditions, and culture of Native Hawaiians. That's Section 101A of the Act. It's saying that the policy of this act is to enable Native Hawaiians. Who? Native wine, small n. What is small n native wines? 50% or more blood quantum. So for those of us with 50% or more blood quantum and 18 years of age or older, we the ones hold the key to the land. We hold the key. We the one can unlock the doors. To return to their lands, which means we can go on the lands. That's our lands. That's ours. We have the right to go onto our lands. And to return to the lands in order to fully support self-sufficiency. That's the purpose, so we can be self-sufficient on our own lands for native wines and for self-determination of native wines in the administration of this act. And for self-determination in the administration of this act. Right? So, well, what happens if the administration is not doing what they're supposed to be doing for us? We get the right to do it because it's our trust, our lands. We get the key. If they're not trust beneficiaries, they got shit to say. No. And the preservation of the values, traditions, and culture of Native Hawaiians. B. The principal purposes of this act include, but are not limited to, establishing a permanent land base for the benefit of, and use of Native Hawaiians. That's what the land base is there for. It's for us, for use. Not for non-Hawaiians for use. It's for us for use. Right? And I'm going to answer that question. Can non-Native Hawaiians have access to our lands? Can they? I don't think so. Not without us. There's a section that talk about that. No matter how they twist and turn their head and all kinds sideways and go, yeah, it's this way. No, the plain language is clear. We have every right to stop that. Establishing a permanent land base for the benefit and use of Native Hawaiians upon which they may live, farm, ranch, and otherwise engage in commercial or industrial or any other activities as authorized in this act, which includes commercial or industrial. See, it doesn't matter what the land classification is. That land classification, that's their classification. That's not our classification. Our lands is our lands, is our lands. Placing Native Hawaiians on the lands set aside under this act in a prompt and efficient manner and assuring long-term tenancy to beneficiaries of this act and their successors. See that right there? That is the breach of trust. The fact that we still get 30,000 almost on the wait list after 100 and something years tell you there is no prompt and efficient manner in which the department has been managing our lands, which the commission, in conjunction with the department, because the commission is the only one that can approve them, and the state of Hawaii, they've all failed to do what they're supposed to do with us. And then we talk about number 3, preventing alienation of the fee title to the land set aside under this act, so that these lands will always be held in trust for continued use by Native Hawaiians in perpetuity. Which means you cannot sell the land. The land will never be able to be sold. It's always going to be in our hands in perpetuity. That's forever. 4, providing adequate amounts of water and supporting infrastructure so that homestead lands will always be usable and accessible. How are you going to have land with no more water? So they scam, they go, oh, we're not charging you for the water, we're just charging you for the service to bring the water to you. Well, I don't need your service. I can get the water myself. Think about it. 5. Providing financial support and technical assistance to Native Hawaiian. Okay, this one right here, this is a red herring. Don't do it. Don't take no dime from them. You take a dime from them, you're you're acquiescing to their authority to tell you and dictate to you what you can and cannot do with your own land. They're not giving you money, they cannot tell you shit. They're not paying your bills. Then C, in recognition of the solemn trust created by this act and historical government to government relationship between the United States and the Kingdom of Hawaii, the United States and the State of Hawaii hereby acknowledge the trust established under this act and affirm their fiduciary duty to faithfully administer the provisions of this act on behalf of the Native Hawaiian beneficiaries of the act. So if they never faithfully carry out administer this act, then who will? We gotta go caught 100 million years? Let a whole generation die before a decision is made? I don't think so. Why? It's our trust. We need to grow up and become adults about this. We need to do that. Now, this is my favorite part of this act. Nothing in this act shall be construed to affect the rights of the descendants of the indigenous citizens of the Kingdom of Hawaii to seek redress of any wrongful activities associated with the overthrow of the Kingdom of Hawaii. Now, that, I love that. That's why, all our people out there that's fighting the good fight with the traffic stops and all that, and the claiming, no treaty of annexation and all that. There's something there. There is something there. See, these are outstanding issues that we have that has yet to be solved. And unless and until that is solved, we'll always have that. And if we always will have that, we'll always have that hope that we can rectify the wrongs from the past. I love that section. And then D2. D1 is what I just read. D2 is next. Nothing in this act shall be construed to alter the obligation of the United States and the State of Hawaii to carry out their public trust responsibilities under Section 5 of the Admission Act to Native Hawaiians and other descendants of the indigenous citizens of the Kingdom of Hawaii. If you can trace your descendancy back to the Kingdom of Hawaii, then you're included in this, right? 5, and that's Section 5. Section 5F is where the money's at. That's supposed to come to us. But that's not how the state of Hawaii was dealing with the money when they first came into being the state of Hawaii. They owe us. They owe us. Okay. So now that you understand that, there is section 10H-2 I want to talk about. Hold on one second. Okay. Let me go get something to drink. Nothing less than good fresh water for drinking. There you go. Okay. It's 12:05 after midnight on September 2nd. And this is what I'm doing with my time. All right. However, statutes 10 is 2 purpose. regarding Native Hawaiian recognition. The purpose of this chapter is to provide for and implement the recognition of the Native Hawaiian people by means and methods that will facilitate their self-governance. So they're supposed to be helping us um, to gain our self-governance, right? To facilitate their self-governance, including the establishment of and amendments to programs, entities, and other matters pursuant to law that relate or affect ownership, possession, or use of lands by the Native Hawaiian people, and by further promoting their cultural heritage, entitlements, health, education, and welfare. That was in the laws 2011 Act Session Laws 2011 Act 195, part of Section 2. You see that right there? So when you read Section 101 of the Hawaiian Homes Commission Act and you read Section 10H-2, both purposes work together to form one thing. What is the one phrase that you see in both of them? Self-governance. Self-governance, self-determination. So what does self-governance and self-determination mean? It means I determine for myself what I'm going to do on my own land. It means I govern myself on my own land. And it also means I'm not asking the government for handouts every 5 minutes because my sink went broke, my roof is leaking or whatever. Bruh, that's your house. You go fix them. That's your kuleana. But if you're a welfare-minded person, then yeah, you're going to continue to suck at the tit of the state. And I'm not trying to get our people there. So this is the lessons that we need to read. So when you get time, go to Session Laws 1990, Act 349, Section 1, and all the rest of the sections of it, and you will see the power that is there. And this comes to the end of what I was sharing with you folks. Only us. There's nobody out there that gonna save us. There's nobody out there that give a rip about us becoming self-sufficient and practicing self-determination, practicing self-governance. Nobody out there. Even the state who professes that they want to do that, you see, they block us at every chance and every turn. They're going to block us, right? They're going to block us from the 600 million. They're going to block us from this. They're going to block us from that. You know, can build kakako makai. You know, can do this. You know, can do that. Oh, this law, that law, this law, that law forbids all of this. Bogus. None of those laws attach us on Hawaiian homelands. So what I hope that our people would learn from this lesson. It's time to act. It's time to practice self-determination. Time to practice self-governance. We have every right to be on our lands. They have no right to continue to hold us back off of our lands. And no, you do not need a letter from a lender that says you qualify for a mortgage just to get a homestead lot. No. Did they pass that through Congress? That's an administrative rule. See the administrative rules? This is the question I have for all you scholars out there. If Hawaii creates administrative rules that have the force and effect to modify the Hawaiian Homes Commission Act in such a way as to change the very nature of the Hawaiian Homes Commission Act, isn't that supposed to be approved by Congress? And if the answer is no when it comes to mortgages, then how can the answer be no when it comes to the 132nd that was approved by the Hawaii State Legislature in 2017? Peace, love, and happiness, y'all. We're out of here. Good night.